I wanted to ask about the Supreme Court judgment. Obviously, the civil service will operate its kind of 4 key values, particularly around integrity and honesty. But I'm flabbergasted why 10 weeks after the Supreme Court judgment, you're not implementing the law. Why is that?
So first of all, the government's really clear. We accept the ruling and will take the action necessary to implement that. There's a range of action that we have been taking already in a request from the Cabinet Secretary for Social Justice. I've convened a short-life working group for all areas to be represented, to take stock of the actions that we need to take to make sure there's a common understanding of where we are and to share any insight that we may be gleaning from other approaches, for example, the UK government or the Welsh government. And these are the actions that we are taking while we wait for the end of the EHRC process to review their statutory guidance. That consultation ends next Monday. I think I'm right in saying they'll then move to finalise that. And once that's finalised, we'll be able to take a further series of actions.
But that's contrary to what Baroness Faulkner says, and I'll quote her. "We have been clear in our public messaging and in direct conversation with duty bearers, including the Scottish Government, that they should not wait for our guidance, but should be seeking to update their policies and practices in the light of the new understanding of the law." So they're quite clear that you should not be doing that, and they emphasise that. They're quite clear that they've stated that to you, so why are you not doing so?
So our understanding of that letter is that is for us to take action. We are taking action where we think that that's appropriate and possible, pending the finalisation of the HRC guidance.
Even although Baroness Faulkner, this is in the public domain, is saying that you should not wait for their guidance.
Well, in order to take action, my point is that we are taking action. But there's a range of different actions. With some of those actions, I think we'll have to wait for the guidance because we have to understand what the statutory regulator is proposing for how we deal with some of the complexities of the situation.
For action at the moment that is talking about it, why then has the Scottish Parliament corporate body unanimously agreed to act with haste to take account of the law? How were they able to do that? And to what extent is that linked to the fact that they bear personal liability if they didn't?
Every public body has to take its own decision in light of their understanding of their legal duties and based on the advice that they are getting. We in the Scottish Government are in a very similar position to the UK Government and the Welsh Government in our understanding of our responsibility being that we need to wait for the guidance for the implementation of some actions. There is a series of actions that we are taking now so that when the guidance is finalised... So
what actions have you actually taken beyond talking about taking action? I'm not clear about that because I haven't seen any guidance beyond every set of wording from every minister and Cabinet Secretary is we are not doing anything beyond talking. That's the Short Life Working Group. And we're waiting for this guidance that Baroness Faulkner's quite clear you don't need to do. So set out what specific actions you have taken right now beyond talking.
Well, so I think specific actions. I can't give you that right now, but the work that's involved in the group and the work that the teams that are represented on the group are taking is to prepare the ground so that when we have an understanding of what the consultation results with by way of the new guidance, we are ready. We understand the policies that are effective and we're ready to implement that once the guidance is finalised.
I referenced that the corporate body, because the members of that bear personal liability, how much do you think that has affected their actions? So, for example, if you bore personal liability, do you think you might have acted as quickly as a corporate body?
I don't know what the thinking in the corporate body, and that's a hypothetical question, I guess, in terms of how I would act in a different situation. Our advice is that, that the correct and the appropriate thing to do is to wait for the finalisation of the guidance.
Despite the risk that incurs, you'll be aware that Sex Matters have already sent a letter dated the 18th of June giving 14 days notice of a letter before action, in other words, a letter before legal action. And I understand it's gone into the public domain today that there's a further email to yourself and For Women Scotland in which they note that if you don't take action, they reserve the right to take further action. So that's two potential further legal cases, which I think, given the strength of the Supreme Court judge, we can anticipate the way in which they would go with potentially a significant loss of public money. I am staggered why you're not acting now, and you're saying, well, we need to wait, when Baroness Faulkner says so clearly that they should not wait for our guidance.
So we're not waiting to take the actions that we believe we can take. The advice that we continue to get, and I haven't seen this latest email, but in respect of the reported other intended action, the advice remains that nevertheless we should wait for the statutory regulator to finalise their guidance.
You're in charge. Who's giving that advice? Is this your advice? Because who's giving that advice?
Well, this is advice from the relevant officials that support me in these matters. But
you're accountable. You're the accountable officer.
Yes, that's right.
And so, do you not think maybe you should question that? You're being told that you should wait for advice, and now you've got two concrete threats of legal action. Does that not worry you a wee bit? Well,
as a matter of good practice and operation, I always probe and test and question the advice that I'm given. I am assured that the advice that I've got is the correct advice.
Right.
And as I say, we find ourselves in a very similar position to our colleagues at Westminster and in Cardiff.
Well, I think my firm advice to you would be to look afresh at that. It's no justification under law, frankly, for you to say, well, that's what everybody else was doing. The Supreme Court judgment was compellingly clear. There's a threat of two further potential legal actions. My firm advice to you, Permanent Secretary, would be to get on it, because I think from a public sector, you are ultimately the accountable officer responsible for ensuring the Scottish Government upholds the law. And regardless of your view in this matter, I personally think it's a very poor look that we're 10 weeks later, we haven't done anything about it. Thank you, Convener.